There's nothing in Amy Coney Barrett's record that suggests that she's about to overturn Obamacare. It's just nonsense.
I mean, there's a lot in her record that's missing too, like experience. Listen, personally, I don't care which party wants who as a Supreme Court judge. What matters to me is, do they have the experience? Were there nobody else, no other conservative Republicans qualified for the job? It says here, Barrett has spent virtually all of her professional life in academia. Until President Trump nominated her to the Seventh Circuit Court of Appeals in 2017, she had never been a judge, never worked in the government as a prosecutor, defense lawyer, solicitor general, or attorney general, or served as counsel to any legislative body, the usual professional channels the Supreme Court nominees tend to hail from. You would think that would be important, but apparently not.
Absolutely lose it because they don't believe in the traditional vision of the courts. They don't believe in Federalist 78, where Alexander Hamilton called the Supreme Court the least dangerous branch, where he declared that the judiciary has neither force nor will, and that if it were disposed to start exercising its will instead of simple judgment, it would lose its reason for being. They just disagree with Alexander Hamilton. They think that the court should basically just be another democratic super legislature.
We can agree with Alexander Hamilton all day long, but I think one of the things that people tend to forget is that people can be terrible. And just because the Supreme Court is said to be a certain way doesn't necessarily mean that that's how it'll be for the rest of the existence of the United States of America, right? But full disclosure, I started doing my research for this video, and I fully intended to look and get some digs off of Supreme Court. And I found very little that would concern me, at least for now, regarding the decision-making process of the Supreme Court. Here's a little bit of what I found. So on an article surrounding the idea that Trump could disregard the Supreme Court, one of the topics brought up two instances. For example, Worcester versus Georgia, 1832. The High Court sided with Native Americans and ruled against white settlers who sought to remove them from their land. President Jackson steadfastly refused to enforce the ruling, informing the court, Chief Justice John Marshall has made his ruling. Now let him enforce it. Marshall did not take Jackson up on his offer, and the order was never enforced. This is what led up to the Trail of Tears, folks. This is where a lot of natives died in the relocation. Fast forward to the administration of Abraham Lincoln and his decision to suspend the writ of habeas corpus, a critical civil liberty protection by the Constitution. The Chief Justice of the Supreme Court, Roger Taney, ruled that only Congress, not the President, could take such constitutional action. Notwithstanding Taney's abhorrent racist decision in Dred Scott, he was right on the law in this instance. Lincoln refused to enforce a Supreme Court order and was never challenged. Now with that, alongside a bunch of things I'm going to bring up in a bit about another topic, it actually diffuses a lot of my concerns that I had about the Supreme Court, even though they have more Republican judges than they do Democrats. My only issue really is Barrett, and only that because she's so inexperienced. And having given her this position, it brings up too much of a fear that, hey, I hooked you up, you hook me up now too. And judging by this political climate, I just don't see that as too far-fetched.
Amy Coney Barrett is not striking down Obamacare. It's not a thing that is going to happen. In fact, she was on a moot court and she didn't strike down Obamacare.
Oh, snap, y'all. Ben Shapiro here, letting you know what's what. She was in a moot court, guys. Calm down. Quit getting your panties in a bunch. Or your briefs. Or your G-strings. I don't care what you wear. Don't have them in a bunch. Don't worry about it. She's not going to do anything. She was in a moot court, guys. Jesus. Wait a minute. What exactly is a moot court? Moot court is a co-curricular activity at many law schools Participants take part in a simulated court. Wait a minute. Simulated court or arbitration proceedings, usually involving drafting memorials or memoranda and participating in oral arguments? That's it? That's a moot court? So, whatever's discussed in a moot court has no way, shape, or form an impact on actual law? But we're supposed to take her up on her word on a moot court? Simulation, a law school's version of Dungeons and Dragons, and I'm supposed to take it seriously? Listen, I am not here saying that this is what she's going to do. I am simply saying that to use that as a defense against the idea that she would overturn Obamacare is stupid. I am not saying she's going to do that. I'm just saying that anybody who's using this as a defense for that, it's a dumb argument.
Right, Democrats are going nuts, similarly speaking, over a 5-3 vote along ideological lines last night. There's a case called Democratic National Committee versus Wisconsin State Legislature. The Wisconsin State Democratic National Committee had been pushing to allow mail-in ballots to be counted if they arrived as much as 6 days after the polls closed on Election Day. A lower court had shot down that plan. Justice Roberts joined the 4 conservative justices in refusing to overturn their decision.
Okay, so now we're going to get to the next part of why I have less concerns about the Supreme Court and the decision-making purposes. Not specifically that I don't have any concerns, but it's something important to know when you look at the actual data. Now here we are. Why the Supreme Court let some states count mail-in ballots received after Election Day but not others, by Ariane de Vogue. I hope I said that right. Here, Roberts' role was critical, and he sided with the other 4 conservatives. The ruling came down before Barrett joined the bench. He explained that the federal district court had intervened in the thick of election season and intruded on the state lawmaking processes, which didn't allow for extending the mail-in deadline. The court made clear that federal courts shouldn't interfere to change state election rules so close to the election. But if we keep on going down, right, let's say, for example, Pennsylvania, the Supreme Court had a 4-4 split. So Pennsylvania gets their 3 days. There is some differences here, but Alito noted that Pennsylvania has agreed to segregate the votes that could be in play for the election, those that arrive after Election Day until 3 days afterwards, and didn't foreclose a challenge after the election that would only likely occur in the rarest of circumstances. North Carolina, mail-in ballots can arrive up to 9 days after the election. What's this 4-4 split? Again, you're seeing this 4-4 split in North Carolina and Pennsylvania, my now home state. And then it comes in to talk about this Barrett factor and the fact that she wasn't allowed to make a decision, and most of it is because of the fear of how that would look. But it doesn't say that she may not have anything to say afterwards, though. Like here it says, with time it will be revealed if she is part of the wing of the court that wants to move things radically to the right when it comes to election law. You know, I'm seeing that 4-4 split, right? You have a conservative, at least one of the conservatives, voting for the right of the state to extend the drop-off date. And that tells me that in at least as many times as they could, the Supreme Court made the split so that whatever it was that the state decided, they could do it. And I think there was only the one issue with Minnesota because of the specific court which made the decision, or made the decision too late in the game.
The lower court's ruling will now stand. The late ballots will not be accepted. So Wisconsin cannot count mail ballots that arrive well after the polls close, which makes perfect sense because obviously it's going to be difficult to tell who is voting after Election Day and who is not.
Definitely going to be something difficult to do. But as Americans, I think allowing the states to extend the time frames is perfectly fine given current events. This year hasn't exactly been the best. But when we take a closer look, how much more difficult is it going to be? Right? Because you're saying it's going to be difficult. Well, a lot of states already have their requirements. Now here we are with vote.org, absentee ballot deadlines by states. This is the soonest you can get your absentee ballot application, right? And here, voted absentee ballot is due. Postmark 1 day before election day, received by noon on election day. A lot of these places have these things. Received by 7 p.m. on election day. Postmarked by election day and received 10 days after election day. But you see, there's already a framework here that will tell you, hey, okay, did it meet this requirement? Did it meet this requirement? No? Then we don't count it. Yes? Okay, then we count it.
Yeah, but again, Democrats get angry at the court when they don't get what they want from the court. Not when the court violates the Constitution, but when they don't get what they want.
Huh. That's an interesting point he brought to the table. Especially since it's Republicans complaining right now about extended cutoff times for mail-in ballots. Especially since it's Republicans fighting to throw away over 100,000 votes in Texas because they went through a drive-through instead of inside of a building, as if that somehow invalidates a person's vote. Yeah, sure. Your vote counts. Vote this election. So long as it's beneath a roof the way our founding fathers intended it to be. But yeah, sure, it's just the Democrats complaining.
Again, the irony of this argument cannot be overstated. Democrats started this with regard to judges. They did. It was Democrats who violated every prevailing norm for generations in order to get judges they want and to reject justices they didn't like.
Some have protested that court packing would be an abuse of power, but political maneuvering over court seats dates to the beginning of the country. When Congress established the Supreme Court in 1789, it stipulated that the court should have 6 justices. 12 years later, Thomas Jefferson won a bitterly fought campaign against President John Adams, and control of Congress flipped from Adams' Federalist Party to Jefferson's Democratic Republicans. So in the lame duck Congress, the Federalists attempted to hold on to some power by legislating that the next justice to retire would not be replaced, reducing the court's total number to 5. But Jefferson and the new Congress changed the number back to 6 and eventually added another seat. Or in the following decades, the numbers of justices rose to 9 and then to 10 and then came back down to 9. Congress has kept the same number of justices since 1869, but it is not constitutionally fixed, and history has shown that it is Congress's prerogative, subject to the president's veto, to add or subtract from the seats on the court. It was an issue between the Federalists and the Democratic Republicans. But I suppose it's just easier to blame the Democrats. Yeah, I can see how that works. It's not like parties have ever, changed their identities. It's not like the Republicans were ever liberals. Liberals. Ugh, gross. Listen. Benny boy here flip-flops. He had beef with Trump. The only reason he's going for Trump now is because he doesn't like the Democrats. It's not that even that he believes in Republicans, right? It's the closest thing to conservative ideology he's gonna get, and he decided to go there because I kind of said in my other video, these people are weak. They can't fight for what they believe in. They're gonna just go for what's easy and whatever gives them the most. But it is what it is. This has been a message from your national idiot. I want to leave you with a little clip. Have a good one, folks.
The establishment, the media, the special interest, the lobbyists, the donors, they're all against me.
We calculate that Donald Trump taking over the Republican Party for the foreseeable future is a lot more dangerous to the future of the Republic than Hillary Clinton continuing us toward the cliff the way everybody else has for 4 years.
We're going to do the right thing for the people of this country for the first time, maybe in many, many decades. We're self-funding the campaign, no special interests, no donors. I don't think people really appreciate it because I see all of this money being poured into commercials, and it's not their money, it's special interest money. And this is on both sides. This is on the Republican side, the Democrat side.